time that was kind of overseeing the home rule stuff. Josh Jarrell was in my office. We were all on the phone, and their lawyer, Steve Connolly, at the time, and we were all sitting there, and everybody agreed the fire marshal's office will change some of the rules to make it easier on those cities, the smaller cities, to get a certified person. They will not go forward with their home rule power, and we will change the home rule statute to preclude, to limit the ability to do what's in there now. And so that was a race to trying to keep, and then we got everybody to file continuance with the Supreme Court, and to go up there and get that done, and we got it done. And then the governor vetoed the bill.
Is that right?
Yeah, then the governor vetoed the bill, and we're like, oh my God, was this case in the Supreme Court? Yeah, that was in 2017, and because they didn't understand home rule, and he changed it from commerce, because commerce had been handled in a different view, right? And then when he came in, he sent it over to Hardy, and he changed it from commerce to revenue, and the perspective of home rule started becoming a different thing, and so he vetoed it.
Getting ready to start here, Paul.
We already started. I mean, are they not listening?
I know.
The mics are on. Good seeing you, Paul.
And Sean McGinley and he always mentions you, and because we were litigating the gun litigation for 4 years against the locals, the Citizens United folks, but he always says, Professor Bastress has got an opinion on this.
I think we're in trouble. Paul's on a roll already. So, gentlemen, try to be brief and concise.
I don't know any other way.
I cede my time.
I was going to say the opposite. For me, not for you.
I didn't even make it to the cookie table. You're in charge up here. You want to eat the cookies? Do it. Well, maybe Jesse's in charge.
I'm the moderator, so we're going to get rolling. All right, welcome everybody, and thank you for coming this afternoon. I think all the sessions have been good so far, and I'm a little biased, but really looking forward to this one. I'm going to give a brief introduction, and then each of the gentlemen to my right is going to spend 5 to 7 minutes. And it might be hard keeping some of them to 5 to 7 minutes, but talking about particular aspects of home rule in West Virginia. And at some point, we're going to turn it over to y'all for any questions that you might have. This is really exciting for me, particularly as an academic in West Virginia, who has been looking at home rule, Dillon's rule issues for well over 20 years now. Because in 2007, West Virginia adopted the home rule pilot program. And Paul and I were talking last night. Paul calls it home rule light. I say it's really Dillon's rule. Who knows what we can call it. But I think the point is, and we may or may not have disagreement on this, but I think it has been wildly successful. And it has been a model for at least one other state. Vermont has introduced a bill to adopt a home rule program almost identical to what is happening in West Virginia. So however you label it, this program that we have in West Virginia has delivered a lot of the benefits of home rule. And I think what we're going to hear from some of the folks on the panel here is that it's really helped local governments in West Virginia, or at least municipalities in West Virginia. And I'm not going to spend a lot of time on introductions, but the person to the farthest right of me, a lot of you know, Professor Robert Bastress from here at WVU College of Law. Then next to him is Ryan Simonton, who is with, is it Casto?
Casto and Cheney.
Casto and Cheney, and he, among the things that he does for the law firm is represent the city of Morgantown. And then right next to me is Paul Ellis, who was the former city attorney in Charleston, West Virginia, and who was involved intimately in the development of the Home Rule Pilot Program in West Virginia. So I'm going to start with Professor Bastress, who's going to give us some of the background issues on Home Rule in West Virginia.
Yeah, what I assume my task is to sort of catalog the history of municipal powers and local government powers in West Virginia. And it's been a pretty steady, it's not a trajectory, it's been pretty flat actually, since the 1880s. That's when the state adopted Dillon's Rule, which was originally articulated in 1868 in a case that Judge Dillon wrote and then restated in his treatise. And I assume by now you know what Dillon's Rule is, that cities may exercise only the powers expressly granted to them or necessarily implied, and any doubt should be decided against the local government's power. So we adopted that rule in the 1880s. And not too long after that extended it to counties as well. So basically local governments have been under the aegis of the Dillon's Rule throughout most of West Virginia's history. The state Supreme Court applied it with a vengeance in some cases. Most notably a case, to my knowledge, it's the most drastic measure of state exercise of state power over local government. In 1915, Governor Henry Hatfield convinced the legislature to enact a statute which wiped out the City Council of Williamson and created a new one under a different charter, and then gave the power to the governor to appoint the new city council. To my knowledge, that fortunately has not been repeated in the United States, although it's being proposed by this year's legislature to some extent. That's another story. So that case was Booton versus Pinson, which would not survive what we enacted, hopefully would not survive what the state enacted in 1936, which was Article 6, Section 39A of our state constitution, which was entitled Home Rule for Municipalities. And it did a number of things, but among them was to take away from the legislature the power to enact city charters for towns or cities over 2,000. The old constitution had already prohibited it from enacting charters for towns under 2,000. So now creating city charters remained with the cities themselves. And then it also provided that cities shall have the power to enact any law promoting its municipal affairs so long as it is not inconsistent with state or federal law. So basically, it described what we've come to call legislative home rule, that the city can do anything it wants so long as it's not prohibited by some other higher authority. And that was quite different, of course, from Dillon's Rule, because he could only do what was expressly authorized or necessarily implied. So that was 1936. The first case to construe the constitutional amendment, which again says home rule, was a case in which the court said that what the home rule amendment did was to codify Dillon's Rule, or to constitutionalize, I should say, Dillon's Rule. So now it was being interpreted as essentially a limitation on municipalities as opposed to an expansion. And that continued. The court continued to apply Dillon's Rule in any case involving municipal power right through the legislature's entire rewrite of the municipal code in 1969. And that rewrite did a lot of things, but for our purposes, it enacted a number of provisions which presumably were attempts to try to implement what was the literal meaning of Article 6, Section 39A. The provisions included Section 817, which said that the provisions of this chapter shall be given, meaning the municipal code, shall be given full effect without regard to the common law rule of strict construction, i.e. Dillon's rule, and particularly when the powers are exercised under a city charter. So the powers shall be given full effect without regard to the common law rule of strict construction, and other provisions said that the cities make and pass all needful ordinances, bylaws, resolutions, etc., not contrary to state law or the Constitution of the state. A clear adoption of Article 6, Section 39A, and there was another section, 812.2, which basically said, here's this home rule, we want a very broad interpretation of it, and we want you to give it a full effect, and then it had a very elaborate definition of what home rule powers were. So the first case after the 1869 statute was a case called Rogers versus City of Charleston, which drew into question the City of Charleston's entry into a contract for sale of property. South Charleston owned some property along what became Corridor G. It was quite valuable, and it entered into a contract to sell. There was a state law which said municipalities shall have the right to sell and buy real property. So South Charleston entered this contract to sell in the future if Corridor G materialized. And the Supreme Court said, well, yes, the 1969 rewrite of the municipal code, and particularly 817, was designed to loosen the common law principle of strict construction, but not to eliminate it. And then the court went on to conclude that because the legislature had not given the express power to enter into a contract to sell, but only to enter into purchases or sales of real property, it lacked the power to do so. So it was, in effect, an application of Dillon's rule, really with a vengeance, that you have the power to sell property, but not to enter into a power to sell it, a contract to sell it. And the court continued after that to recite Dillon's rule as the law in West Virginia with regards to municipal powers. And then we reach the last case, next to last case, was a case called McAllister versus Nelson, which dealt with the ability of Huntington to create a mayoral veto, even though it was not expressly authorized by state law. It's a weird case. It had two syllabus points. The first syllabus point, i.e. the holding in the case, was Dillon's rule. City of Huntington could only exercise what powers were expressly given or necessarily implied. And then the second syllabus point was a restatement of Article 6, Section 39A, and the justice writing the opinion didn't realize there was any tension at all between syllabus point 1 and syllabus point 2, which was characteristic of that particular justice, by the way. And then we get to the most recent articulation of this was a case called Robertson versus City of Bluefield in 2016, which again applied Dillon's rule, cited Dillon's rule throughout the opinion, never even recognized the existence of Article 6, Section 39A, and said that even though there was a statute authorizing cities to regulate and, if need be, eliminate dangerous animals, it could not survive a similar grant to counties to for citizens to petition counties to put to rest a vicious dog, and that preempted, in effect, the city's powers. Again, applying what it described as Dillon's rule that was probably somewhat different. So this history of this, really what is judicial nullification, I mean, it's the most stark case of judicial nullification of a constitutional provision and what are clear expressions of popular support for broad interpretations of municipal powers, I think led to the efforts by the Municipal League in 2007 to initiate the Home Rule Pilot Program, which eventually became a permanent program last year. And I think I'll stop. Am I over?
You're great. Thank you,
Okay.
Professor Bastress. And Paul, you're considered the author of the Home Rule Pilot Program. Tell us.
The good parts.
Yeah, okay. And Ryan wrote the bad parts?
No, absolutely not. He was in law school, right?
That's
Yeah.
right.
But can you tell us how did this come about and a little bit about the process of getting that through the legislature?
Sure. I do want to say this is looking back at 2007 and then sitting at WVU Law School, having a whole symposium, home rule is amazing to me, and it's very much appreciated. I mean, this whole thing started. I got a phone call from the Municipal League asking if I could come over and sit down and talk about an issue. And I'd like to think it was because I'm such a bright attorney, but it may be because my office is about 6 blocks away. That may have been, I don't know which. I'm gonna go with the first. But so when I got there were a couple of members of the legislature and they were frustrated about cities. Their belief and my belief, whether it matters or not, is that the state is stronger based on how strong its cities are. And back during that time, there were serious budget issues statewide. There were cities like Huntington who were going down quickly because of some, what they would say, unfunded mandates, some pension issues that were bringing them to the brink of potentially filing bankruptcy as one of the largest cities in the state. All this, and there were things going on all over the state. And so we had the benefit of having some legislators in some positions of power, who many of which had been elected officials in municipalities in their earlier careers. And so we were in a room, and what they said is, we want to give you all what you need in order to start generating positive benefits in your cities, which we believe will translate into positive benefits for the state, because the cities are really the economic engines of the state. And so we had a discussion. I do not remember where the initial draft of this came from. I don't remember. They had a starting point in the room. We looked at it, we talked about it. They wanted to keep it very simple. And so in 2007, what we got, and I hope if Professor Bastress disagrees, then I defer to him. But I think what we got in 2007 is we got a broad-based home rule with almost no restriction, because the only restrictions are, 5 things if you separate them. And it's, don't change the criminal laws, don't violate the U.S. and the West Virginia Constitution, don't violate federal law. Other than that, go for it. And the language in the whereas clauses, the enacting clauses, make it pretty clear that, cities are, we want cities to do whatever they think they need to do to experiment, whether it's for state law benefit in future laws enacted, or whether it's simply to help that particular city with a local concern. And so we got it, and that's what happened. And we went forward, and early on, and this has changed dramatically, and I think that it kind of ties in with what I've heard also with the wonderful speech at lunch about divisiveness and where we're at now. But early on, this is a very good example. You just cut me off when you're done. I mean, it is a very early example.
I figured that would happen.
Charleston, one of the things that we wanted to do up front was we said, hey, look, we've got a serious urban deer problem, okay? And we wanted to extend the period that we could have urban hunting to cull the herd. I mean, it was a safety issue. I mean, there's deer everywhere. And we wanted to do that. We want to extend the season by a couple of weeks. And we wanted to increase the bag limit, which was like 2. You had 2 deer, that's it. And we wanted to do it in a way where we had like some police officers in deer stands on city. I mean, this was legitimately a safety issue. And so we put in here that we wanted to do that. We thought it was very reasonable. DNR jumped up and said, if you do this, we will lose $5+ million in federal funding. And then they gave us the contact information of a person who we couldn't get on the phone from the federal government, but on his website, he was off in a tree stand somewhere in the jungle, okay? And so we said, well, we don't agree, and we want to do it. So the reason I give you that example is because then the legislators were in a position where they told DNR, that's what home rule's about. Get used to it. If you don't like it, sit down and talk with the city and see if you can work out a mutually, beneficial resolution, which is what happened. We sat down with them. Once they realized they had to talk to us, they sat down with us and we came up with, they agreed and we came up with a solution. And they said, could we do that by rule instead of you doing that through your own ordinances? And I said, I don't care. We're just trying to solve a problem. So that happened, and it was probably the first statewide enacted kind of rule that came out of home rule. But the reason I give that example is between 2007 and now, that's disappeared. I mean, what's happened is most of these, you start off with these 3 kind of prohibitions. Now we have over 30. That's why I call it home rule light. I mean, it was broad-based, but now it's broad-based provided you can't do any of these things, and pretty soon there's not going to be much left. That being said, the journey has been amazing. If you're a law student and you're looking for something that gave you the chance to be an advocate, a researcher, get into legislation, go into court and fight or defend, I mean, this was a real dream kind of thing. Some of the most, in my opinion, kind of the new frontier in law in West Virginia for a period of time, maybe still is, but being on the ground floor of this was just really exciting, also frustrating. But anyway, that's kind of the broad brush.
Yeah, and I think it still is for law students. Yeah, you can still get a job. But so Ryan, can you kind of, Paul has given us this broad brush, but it really wasn't just all municipalities can go do what they want. And I think it started with 5 up
4.
to, I think it was up
There
to
were 5 available, but only 4 came in.
did it. And that was Huntington, Charleston,
Wheeling and Bridgeport.
Wheeling and Bridgeport were in that first wave of class 1s that qualified. Now, if I remember correctly, it's up to 44, and it includes up to 4 class 4s per year that can join. So Ryan, can you tell us a little bit about the program structure? And you represented Morgantown, who I think was in the second wave. And so you made an application to the Home Rule Board. How did that work, and how has that benefited, or has it benefited cities in West Virginia?
Right, that's great. So it's, we have the long history and context of the creation of the program, and then in 2007 this pilot was created with 4 initial municipalities and a home rule board as a kind of gatekeeper for these home rule powers granted to cities. And I of course wasn't with the city of Morgantown at the time, but I believe they elected not to apply in 2007, and so there are only 4 of those 5 available spots filled. But as Paul mentioned, the only restrictions on authorities in that initial phase of the program were against violations on the Constitution, federal law, and criminal laws of the state. And so you had some really important initiatives brought about by that first round of cities, and with some challenges too. I mean, Huntington tried to implement an occupation tax and was challenged on it. They also had a land bank fast track authority initiative that I think is kind of a precursor to what we have with land reuse agencies now, but was challenged and had some difficulties. So it was 7 years of that pilot program arrangement before the program was opened up to additional cities in 2014. And so phase 2, Morgantown did participate. I forget exactly how many it was opened up to then, and Paul may recall. 16. I wasn't yet representing the city, but they applied and were admitted. And many of those original phase 2 cities implemented just a lot of the initiatives of the original round of cities. So I think you asked for just a bit of procedure. So basically a city can submit an application to the Home Rule Board, which is appointed by the governor and various representatives of other organizations, has 5 members. and the board elects to grant admission or not, generally grants, and then you would submit in the initial phase a plan application along with the ordinances you would like to adopt. From the second phase onward, you would just submit your written plan, and ordinances weren't directly approved by the board. So there have been two more iterations since then. It was up until last summer a pilot program subject to a sunset provision. Home rule has now been made permanent, at least without an end date. The Home Rule Board remains in place, so the basic procedure remains the same. There are some extra steps now. There's an annual fee to be paid by municipalities. There's a certification before a plan amendment can be approved that you are up to date in all your fees. And there's a certified mail notice requirement to the head of each cabinet secretary to provide notice of a forthcoming amendment. As Paul mentioned, there has been an increasing list of restrictions on the authorities that cities may seek under the Home Rule program. That list is up to 24 separate paragraphs now, but I certainly don't doubt that number of prohibitions is higher. But it is, all that procedure aside, or maybe because of all that procedure, it is a helpful tool for municipalities and has been used to some really good effect. Professor Bluestein's speech at lunch touched on the difficulties in states where municipalities are given broad but maybe ambiguous authority, and this program has the virtue of some certainty for practitioners and for the governments. You, presumably, if your city applies to the Home Rule Board and is granted authority to implement an ordinance in the first phase or a specific authority in the second, then there should be no legal challenge to the municipality's authority to implement that through law. And despite some restrictions in the program, it offers municipalities a lot more flexibility than they had under previous law, which Professor Bastress noted is confusing. You have a tangle of competing grants of authority and restrictions on authority, and it can be difficult to ascertain up front whether a municipality may act in a certain manner or in a certain area. So this process to give a specific grant of authority and to allow a municipality to investigate that and describe in a very public way how they'll address it is a way to promote that flexibility and also to ensure certainty. And certainly, I mean, it sounds like one of the drivers of implementing the program was at least shoring up the finances of municipalities so they can survive and provide the citizens the services they expect from a city, right? And that's been something widely implemented through the 1% sales tax that was authorized in the program. And then finally, I would say a virtue is responsiveness. Governments have been able to become more efficient in adopting agreements with other government agencies, become more efficient in how they manage and dispose of their property, and grant their people providing direct services, whether that's code enforcement or fire marshals, more authority to act quickly in ways that the residents have really demanded.
Now, you've alluded to a couple powers that are desirable, but what type of authority have local governments gone for under the Home Rule program?
The most common authorities are almost unanimous adoption of the 1% sales tax that is authorized under the program. Municipalities enacting that have to reduce their business and occupation tax, which is one of the other main funding sources for municipalities. Many municipalities have used Home Rule to obtain authority to dispose of real estate directly, which was a Charleston initiative in phase one. Prior to that, a public auction was required to sell any piece of real property. I think Paul will talk about this later, but spot citations for property violations, accumulation of debris, failure to mow grass, was and is a common authority sought by municipalities through the program. So I think those are three main types. There are really, I was kind of surprised in looking through the minutes of the Home Rule Board and preparing for this that a lot of municipalities continue to come in and they continue to address additional local matters through the program. There are some big upfront successes that were adopted statewide, and those seem to have slowed down a bit, and maybe due to restrictions in the program, but it still seems to be a vibrant program.
So yeah, Paul, some of these things that started initially as a home rule power, the legislature said, this is a great idea, let's give it to all municipalities. Can you give us some examples of that?
Well, I would say, so if you talk to a new say going back to 2016, 2017, you talk to a new legislator and you say, are you familiar with home rule? And they'll say, yeah, you mean that 1% sales tax that cities have? But the mistake about that is this program was never about a 1% sales tax. I mean, it took years before that came about after enactment. I mean, the first 3-4 years of this was about solving problems that either cut costs, improved effectiveness, address a local issue that the state, either doesn't care about or isn't going to, enact a law because they couldn't do it uniformly. And so, a few that run, I was looking through that 2019 report too, and it looked like of all those cities, the 40 plus cities, almost everyone did have a 1% sales tax, but they also had, here's a real simple one. Cities can enter into an agreement with another government entity, a county, an urban renewal authority, a state agency, by a resolution. Well, people look at that and they go, well, who cares? Well, I'll tell you who cares. Cities do, because state law says that an ordinance requires 2 readings with a week in between. Many towns, they have 1 meeting a month. So we're going to take, so if a county comes to you and says, hey, we want to do this really great thing with you, but it requires an agreement, and we're ready. We just had a county commission meeting. The commission approved this by resolution. When can you get it? If you're a town, you go, well, 2 months. And then the other thing, or we'll just do it and hope nobody says it's not legal, right? Which is not what I would advise. And so, we streamlined that. Why do you need an ordinance to accept an agreement with a government agency? And then the other part of that code section says then you got to go to the AG and you got to let them review it as to form. And if you don't hear back from them in 30 days, you can go ahead. So we just said, we don't need the AG reviewing our stuff. We're quite capable of that, as are most cities, at least to the extent they have legal counsel, competent legal counsel. And so that was one thing that I've seen adopted. The disposition of property, almost everybody has that. And that was, and the law still says this, why it hasn't been adopted statewide, I don't know. All these have been offered as statewide legislation. There's always been very strange reasons that they haven't. When I tried to do the disposition of property, it died in committee because one of the committee members said, does this mean you can give property to somebody to run an abortion clinic? And I was like, that's not what we're doing here. But no is the answer, actually. But the point was we had homeless shelters, and we had, some people, a needle exchange program, for example, harm reduction. We had those sort of health things going, and the city, and they didn't have any money. And the law says we can lease a building to you, but we can't give it to you, and we got to charge you fair market value. So while there were legal ways to get around it, it was better to just do it straightforward. So that's that one. And then I guess the final part was, if you want a store on this block that serve everybody wants, we need a store here, and the law would require you to auction it so other people could come in and drive up the price or purchase it and say, we're not doing a store here and you're stuck. So, but those are the kind of things. It was 3 years of that sort of law before sales tax ever came along. And the sales tax came along because Huntington then and soon Charleston were going to go under because of the substantially underfunded police and fire pension obligations that had been, that had been done 40 years ago. And people had just been passing the buck. And we had a mayor, and Huntington got a mayor who said, we're going to solve this now. And so, you know, that was the sales tax. It was to try to keep cities whole so that they wouldn't go under. Now I'm not, and Charleston uses an economic driver too with the expansion of and other people have, so I'm not saying it's bad to use it. I'm just saying home rule in this state was not about a sales tax.
Yeah.
So, although I like the sales tax.
And I'll note at the land use clinic, we've noticed that a lot of the initiatives are directed at abandoned and dilapidated buildings. And Rose is here. Some of the things that started in Wheeling and the legislature have now empowered statewide are things like the vacant property registry, which has been very successful. And you couldn't do that before home rule.
No, and that started in 2007.
In Wheeling.
Yeah.
And then Huntington, I believe, had the lien on fire insurance proceeds because there were a lot of people who we suspect started the fire themselves, took the insurance money and left. And then we have a burned out building there that somebody has to clean up. Now the municipality and counties, I believe, have a lien on the fire insurance proceeds up to $5,000 or 10% until that's cleaned up. And so that's been hugely successful as well. Now, Ryan talked about or referred to some individual challenges to individual powers, particularly in Huntington. But the Kanawha County Circuit Court recently decided a case that had challenged the home rule program in general. Can you tell us a little bit about that, Professor Bastress?
Yeah, it challenged it in general, but it also was primarily focused on the 2% sales tax that Charleston, not 2%, 1% sales tax that Charleston had levied. And this was obviously a Charleston resident, one of our grads, who brought this case and made several arguments as to why it was unconstitutional. And actually they were somewhat creative. The first argument used Article 6, Section 39A as the home rule provision in the Constitution as his premise, that he argued that that section required that the legislature regulate cities through general laws rather than local or special laws, and that had not been the case before Section 39A. There were a lot of local laws dealing with cities, particularly city charters. And so he argued that the Home Rule Board, to the extent that it creates, in effect, exceptions from statewide laws, was creating essentially local laws. And I think that fails because Section 815A is the Home Rule statute, is a general law itself. And it allows any city to participate in the Home Rule program, and it allows any city to petition, any home rule city to petition the Home Rule Board for relief. And it's wide open, it's open to everybody, and in my mind that makes it a general law, which would not be inconsistent with Article 6, Section 39A. And the particular tax provision in 815A allows, it's a specific provision allowing cities to request a Home Rule Board to allow it to enact a sales tax if it reduces its B&O tax. And that's no different from the preceding statute, which basically said the local city can enact a sales tax if, in that case, 813C4. In that case, you had to eliminate the B&O tax, but it's the same principle. The city, it's up to the city whether they want to take advantage of what is a general law. The plaintiff's second argument was that, again, relying on Article 6, Section 39A, that cities may not enact laws that are in conflict with state law. And his argument was that, well, if Home Rule Board grants basically a waiver or an immunity from a state law, then that's creating a local law which is in conflict with state law, And I think and the circuit court's response was, well, no, it isn't, because state law created the Home Rule Board and authorized it to make exceptions to state laws, and therefore, by virtue of the Home Rule's authorization, the local law is no longer, is not in conflict with state law. And then it was a very strange, or not strange, novel argument that the legislature was in fact delegating the taxing power, and the Constitution does impose through Section 39A limitations on the state's ability to confer taxing authority on local government, on cities in particular, and that while giving cities a lot of local power with regards to regulatory authorities, the section said you could only do what the legislature specifically provides for in terms of taxation. And historically in this state, the ability of local governments to raise enough revenues to survive has been very, very limited. In fact, there was a study done by ACER, and I forget what that acronym is. Do you remember, Jesse? ACIR? They do a lot of research on local government powers, and they ranked West Virginia as 49th or 50th in the ability of local governments, and particularly cities, to raise revenues. So the cities in this state are really hemmed in. And because of some state law provisions as well as history, this guy argued that the state could not delegate the ability to create different taxing authority to the Home Rule Board, and unfortunately had no authority for that position. And I've never heard of such a limitation on the taxing power, that it cannot be delegable to some other authority. And I think it failed in the circuit court for simply lack of support. And the opinion also, or the petition also made some arguments about deciding two provisions in the state constitution that by allowing these sales taxes, the Home Rule Board was authorizing violations of Article 10, Section 1 and Article 10, Section 9, both of which require taxes to be uniform and equal. But those provisions apply only to property taxes. They have never been applied beyond that. So they would have no application to sales taxes, and in any event, the taxes are equal. They're 1% of any purchase. For those reasons, I think this challenge failed in the Kanawha Circuit Court, and appropriately so. And I'm glad, because I think it cut off a rather novel approach to home rule. And the novelty is in the creation of this Home Rule Board and the ability to get an immunity from state laws, which is not characteristic of other home rules that have come before. And the genius of creating the Home Rule Board is that at least that board makes the initial decision as to the exercise of the home rule power, rather than having to go to a court. And I think that was, I suspect it was part of the strategy to get away from this horrendous history of hostility and, if not nullification, of home rule power. We have yet to have a case in which somebody has challenged a decision by the Home Rule Board as to whether that can even be done, or what the standard of review is, or anything. But at least as an initial matter, you have this administrative board as opposed to a hostile court reviewing the municipal powers.
Isn't there at least an argument that the home rule program delegates legislative authority to an unelected home rule board? And I ask that in part because the only difference between what West Virginia has and the bill that Vermont has introduced is that once a year the Home Rule Board appears before the state legislature and has the state legislature bless what the Home Rule Board did.
Yeah, and of course the 2019 Act, making it permanent, did that. And from time to time, the legislature has done that. It has affirmed or recognize the validity of what the Home Rule Board has previously done. And of course, the legislature maintains oversight and always has the power to overrule any particular ruling of the Home Rule Board. And I would say, in response to that argument, that the legislature is a democratically elected body, and it can delegate its powers as it deems appropriate, as long as it has sufficient guidance. And I think the 815A has it. And as I said, the legislature can always overrule the board if it wants to. And I think another positive aspect of this program is that it recognizes that local governments have local problems which may differ from statewide concerns, and it allows the Home Rule Board to facilitate a municipality adjusting its solution to a local problem, notwithstanding what state law might say. And I think in that way it promotes what the whole purpose of local governments is, to have local elected officials make decisions about local problems and create local solutions to local problems.
And class 1 municipalities might have different problems than class 4s.
Right. If there's any
Or
class
different
1 cities
solutions.
left.
Maybe not.
We may be out of them after
Oh, really?
the
Is
census.
that right?
Yeah. But you're right, it's the same, that's true too.
Yeah. Ryan and Paul, do y'all want to chime in on Jeffries or any of that discussion?
I know Mr. Jeffries. I'm just glad he let me leave the building before he filed that lawsuit, and I wouldn't be so kind as the professor on what I thought about it, so I'll leave it at that. I'd say it was a correct decision by Judge Bloom, and well written, and the folks at the city handled it well, I thought. With regard to your question, though, about this delegation, I mean, initially anyway, if you look at the language in the initial 2007 enactment, the Home Rule Board, if you read the language and then you compare it to now, and I'm not going to do that, we could, but somebody will throw something at me, but what you'll see, and the way the board handled this was, I mean, they weren't really, they were acting as a checklist, as a gatekeeper. The way they handled this for the first 3-4 years, and the language is supportive of that, is that, they're supposed, it's authorized, make recommendations to city, that sort of thing. And when you came in and said, this is what we want to do, they said, okay, let's see. Is it in opposition to one of the 5 things you can't do? No. Did a lawyer licensed in West Virginia sign an opinion letter saying that it was constitutional? Did you follow the process required? And if the box is checked off, it was approved. I mean, that is it. And so they didn't really have a substantive discussion about anyone's. Now, there was some arguments in the drafting by me and some other people in some rooms about the language now. I mean, they wanted to change it so that the board would go from that role to they would analyze and approve every single substantive issue. That's what the push was, and the compromise was basically that they could approve or reject any part for any lawful reason. And we inserted the word lawful in there. I'm not sure how far it gets us, but it was better than for any reason. So they clearly, their role has changed a little bit. And I would note that the legislative auditor back in 2012, they only had 3 recommendations: continue broad-based, no more restrictions, and get rid of the board. And we said, whoa, we want the board. We think it's good to have this board in here for the very reason Professor Bastress just said. I mean, at the very least, it gives you an opportunity to figure out if there's going to be an issue before somebody runs to a court, and maybe a way to resolve it, right? And so, but anyway, the legislature did not follow any of the 3 things in the recommendations from the legislative auditor. They went the other way. So,
I mean, it has expanded to a lot more municipalities, although through a different process. But I think that's an interesting intersection between Professor Bastress's point about this being unique in that it gives immunities from applicable state law compared to other home rule programs, and the discretion of the board, because there have been instances where state agencies who would be impacted by proposed initiatives have come and objected, and particularly with the Sunday brunch bill, where municipalities started before the state legislation came into place to use the home rule program to allow restaurants to serve alcohol on Sunday mornings. And the Alcohol Beverage Control Administration was adamant in attending those meetings that municipalities not do anything other than what would be allowed statewide, which was a 10 a.m. service time at a restaurant or hotel. And there were one or two municipalities who proposed to allow retail sales and to begin that earlier. And those were, I think, withdrawn at the request of the Home Rule Board at their meetings, right? And maybe less entertaining, but similarly, there was a Fire Commission lawsuit against the Home Rule Board based on their grant of authority to Clarksburg and Bridgeport, I believe, to separately license building inspectors. So that it's been a forum for state agencies to protect their regulatory schemes as well.
But now we have Sunday brunch laws statewide, right?
Well, that's well, maybe it's only interesting to me, but there's municipal authority for those under the Home Rule program, and then there's the statewide bill that allows a county referendum. So I think that municipalities who've obtained it under the Home Rule authority, like Morgantown, could do that regardless of whether the county passes a referendum.
And as you said earlier, Ryan, the Home Rule Board gives municipalities certainty. I think that home rule process.
Yeah, that's an advantage of the process, and it seems that way, and it gives it at least the stamp of finality that a municipality can act here. But it has not always been free from litigation or other controversy.
One more question from me, and then I'm going to open it up. But and this is for any of our panel here. I'm going to not hide my feelings on this. Why the heck do counties not have home rule authority in West Virginia? And I know there's been some bills introduced and a little discussion about giving counties home rule. Why not?
So you're opposed to it?
No.
I mean, I was having a discussion with somebody about that today, actually, and what I've heard, at least, when I was up there dealing with city stuff at the legislature and in some of these disputes, and counties would come, folks representing counties, the county lobbyists, what I've heard is we want we want a 1% sales tax, and what my position is on that is those are kind of two different things. If you want a 1% sales tax, then go try to get one, and that's it. I mean, because for me, and I don't know. I haven't heard any proposals from counties beyond that. I'm not saying there aren't any, well, and I'm sure you've got a list for me.
Yeah, but what we hear from counties is dilapidated buildings. Municipalities have much broader authority to address dilapidated and abandoned buildings than counties, and some counties are very frustrated by that.
Well, we have the on-the-spot citation that we didn't talk about too much, but that came up. That came from a building commissioner and a planning director who had seen something going on in Delaware where they would take a picture of the house. And then they would do what is essentially the same as a parking ticket in legal effect, because when given after notice to repair and no repair, it operates as you're guilty, but you can appeal for a fine. And the reason that didn't pass state law is we couldn't get enough legislators to understand that is legal. We even brought case law in; it is legal, and we couldn't get it. But in any event, that's where that came from, and it's been very helpful. But as you know, because we wouldn't have been able to do it without you and Kat, back in 2016, we actually passed statewide law that is the main law that cities use. 81216 is what cities are able to rely on to that fast-track dilapidated building demo. And as I recall, you wanted to bring counties on board, and I said absolutely, and they had no interest. That's my recollection, because we wanted to do a companion section in 17, and I had already written the draft, and then we couldn't get anybody from the counties to jump on board, so we went on by ourselves.
Your memory is correct.
Well, I mean,
And-
so I like I said, I hear counties want 1% tax. They should go get it. I'm not opposed, but that's not home rule.
Any other thoughts on counties?
Yeah, I mean, there's just a history in the state of being suspicious of local government, and that obviously includes counties. I mean, obviously with 815A, we've loosened the reins on cities, and previously the legislature had tried to do so in the 69 Act, but there's just a thread of distrust, I think is the right word, of counties, and their administration and their what would be a temptation to raise revenues, and they've been constricted because of that history.
And that's the number one opposition to home rule that I hear from citizens is they're just gonna raise my taxes.
Right. And I mentioned earlier about the ACER report on cities. Counties were just as bad in West Virginia in terms of their fiscal flexibility.
Yeah, and I have heard from some counties that they don't want it because the fear is that then the state will say, well, now you have all this authority, here's some responsibility, and we're gonna impose some more duties on you and not give you the means to raise revenue.
So the distrust runs both ways.
It does, it does. And I have to say this, one local county commissioner was quoted in the newspaper as saying, only a moron would think that home rule would help counties. It's like, dude, it's voluntary, you know. Okay, now I'll open it up. Do we have any questions from down? We got at least one down here, Gabby.
Oh.
Why wasn't it limited to 5 and then 40 municipalities? And do villages, are they included in those municipalities? And what, is it a geographic, a financial? What are the types of restrictions that apply?
You want to start? You want to pull the restrictions out and read them? It's a long list. So it started off with 5 because they were worried that they didn't know what they were going to get. This majority legislature in leadership that had the votes to do this, they wanted to do it, but they didn't want to start off too big because they were concerned that if people screwed up too much, that it would end before it started. So that's why 5. It opened up over time we started asking for it to increase the year after it was enacted, and we were told, shh, just try not to screw this up, do good things, let's wait for the legislative audit in 2012, and then we'll see what we can do. So that's why. And the list is, I could go through, we don't have time. Hey, I'm happy. After I've got time, if you're really interested, I can go through the list of all the restrictions and I can tell you where each one came from. And they all came from mostly out of state and some in state, but a lot of out of state special interest agenda stuff. A great example is guns. No question.
That was the first edition.
Yeah, they came after guns came quick. They came after us
you, Paul,
because of me.
Charleston.
Yeah,
So it started out with you can't violate the United States Constitution. You can't violate the state constitution. You can't decriminalize something that is in the criminal code, and you can't make your own marriage and divorce laws, basically.
that came later.
Was that later?
Yeah, that's later. That's
And
in
then
the first
Charleston banned guns on public property, and then the next time they go, if you ban guns, you can't participate in the home rule program, basically. I think you had a choice. You could ban guns.
No, what happened is, you're going to take us into a half hour. What happened is, Charleston had a wait period and a 3-day wait period that was enacted in the 80s. And what happened is, and I suggested to somebody yesterday what impact Citizen United had on all this and the related, but What I can tell you is around 2010, the amount of money that was pouring into this state from pro-gun interests, local and out of the state, the local groups, the influence just was. One day I heard from them and we said, no, thank you, we're fine, what we do is lawful, and nobody would listen to them. And a year later, all of a sudden, I'm being told you better change this law or we're gonna gut your laws and we're gonna gut home rule by people who could do it. So, it was almost an overnight change. And what we had is we had a waiting period and we had a 1 gun a month limit in our city purchase. So it wasn't like, okay, what happens when I walk into this city? Do I have to do something different? That was not the case. It was not a uniformity issue. And so we ultimately said, we'll change it because they came up with this crazy law that passed that said, in part, we can't keep guns out of rec centers and Head Start programs. And it passed. And so, it's not about can you have a gun or not, or it's about a city runs a Head Start program with children, with a school bus and a school sign, and they passed a law that said we had to let guns in there, anybody who had one. So that's what happened. And so I told folks, don't worry about it, because we'll use home rule and we'll just go right around it. And so the very next year, before we could even enact something, the gun lobby had already figured that out because they're not dumb, and they came in and they threw it into the home rule to close the loophole. So that's what happened on guns. So.
Yeah, I think you also asked whether towns could take advantage of it.
Yes, can villages participate?
Yes,
What
yeah.
are the requirements on the municipality to participate in the home rule?
Yeah, the latest version, the 2019 Act, towns under 2,000 prior to that could not participate, but now the board can approve for a year. And there are some Class 4 towns that, in fact, are home rule. I know Harper's Ferry is, and some others. So, and they can expand by 4 a year, and there are no limits on classes 1 through 3.
And Ryan had talked about the process a little earlier. Do you apply?
Sure. The applicant municipality will prepare a proposed home rule plan, and that home rule plan has to identify the state laws that are limiting it, what it would like to do, and how that's constrained by state law, and how home rule is a solution to that problem. And you publish 30 days notice of a public hearing in a newspaper, and then you have your council adopt an ordinance authorizing submission of that plan to the home rule board. And now you also pay an annual fee. I think it's $2,500. But aside from that, accessible to Class 4 towns just as well as larger communities now.
Except that Class 4s are limited to 4 added per year.
4 a year.
Are 1s, 2s, and 3s, it can be as many as...
Right.
Yeah,
It's
okay.
open to all. Right.
And I heard some of the larger cities were at first hesitant to allow Class 4s in because they questioned whether Class 4s had the capacity or whether they might do something crazy that would ruin the whole program. And you didn't tell me this part.
No, I was of the mind that
I
the
heard
larger
that on the
cities are more
street.
likely to ruin the program than the small ones as long as they got good legal counsel. But I think there was a concern, but I'm not sure. It wasn't municipal concern.
Well, it's similar to how other states deal with home rule, right? Where you have larger cities as your home rule municipalities and smaller communities as statutory cities with just a defined set of authorities. But I don't know the initial reasoning for it.
Can you talk a little bit about the board membership itself and the kind of the discretion that they exercise? I know it seems, if I recall, that the members of the board have not changed that much since inception, but it did move from one department to another. And when I presented to them in 2017, there was a new member on the board who had some questions that some of the other board members felt a little more established in the answer, and so there was some debate between the two. So could you just address that a little bit?
It was initially run out of the, so there was no funding. right? And one of the things the new one does is provide some funding to the board. So they were operating without funding, and under Governor Tomlin, the home rule board support staff was being run out of Commerce. And so, and who are focused on economic development. I mean, it made a difference to me in the dealings, and I'm not saying everybody has done a good job in my opinion, especially with no funding. But initially it was Commerce, and the language was such that, again, it was a checklist. Governor Justice, and I was just passing Professor Bastress earlier, I don't need it, but I was just passing, the fact that in 2017, when we had a permanent solution to this, and we were trying to fix that lawsuit that was in front of the Supreme Court that had been continued, and we rushed and put some language in the law to say, hey, everybody, will you please dismiss that lawsuit? We're going to fix it legislatively. And then Governor Justice vetoed the bill. And so, and why I say that is he sent this over to Revenue, and so it started being run by the Department of Revenue, different people, different focus, money focus. And things were just different. And I think that's probably what you experienced. I mean, some of the appointments that were in before were replaced by the new governor. And they were real uncertain. They didn't know much about this. They hadn't received the education, on-the-job education when it started up like the other folks. And they were just they wanted to make sure that they were doing the right thing before they did anything. I mean, I think they're doing a good job. It took them a little while. And they wanted money. They want resources. They didn't want to have to stack this out of a back room of Revenue or Commerce. I didn't blame them. Just for what it's worth, the cities collectively through the league that we're in, as far back as 2015, had already offered to pay. Like we had proposed slide scale, class 1, 2, 3, 4. If we could get 4s in, would pay different amounts. I mean, we were on board for paying. It's just not something that got done until 2019.
Anything to add? Other questions?
I actually had a question for the panel. As someone who admittedly knew nothing about municipal law before the symposium, what I have gotten from it is that the number one benefit to citizens are that they get specific solutions to specific problems, is what it seems like is the number one benefit. But I was wondering if from your all's point of view, is there a different, like, number one thing that citizens get out of home rule?
I think that's a good way to describe it, and that the responsiveness to citizen concerns that is allowed by the home rule program is the real social benefit for communities. If there's a state law that has not considered the specific issue, like needing to have fire marshals given arrest authority, or needing to give citations on the spot for particular property maintenance issues, then city councils are the ones that hear that, and they now have a method to address those citizen concerns. I think you're exactly right.
I believe that government is best at the local level. I mean, that's my experience. That's my personal belief. But that's a great reason to have home rule. But that's not what the most important thing of it is here now, in my opinion. And it goes to some of the things I've heard through other speakers. Cities used to have a seat at the table when laws were being drafted that impact cities and the people who live there, who choose to live there. And home rule gave us a seat, just like when I was earlier talking about the DNR. I mean, they said, hey, look, we just enacted this law. You got to listen. I mean, so don't listen to them, but they're going to pass what they're going to pass because that's the law we passed, and they now have that authority. And that forced the DNR folks to just stop that. The state always knows best. We said so, and that's it, right? And they couldn't do that, so they had to work with us. And the end result was a really good one, and it was a win-win. And so having that seat at the table, the benefit of that is huge, but I'm not so sure that we've got that now. And I guess most of the laws that got maybe not passed, but got introduced this year, that impact cities, I know that city representatives were not in the room. They did not most of them did not generate from the league or cities. Most of them, cities were not even in the room. Many of them were kind of punishment, punitive preemption kind of stuff. And over the last 5 years, we've had to kind of fight just to get a seat at the table. And so the thing that I think is the most important about having kind of a broad-based home rule is it gives people have to at least listen. That's all. I mean, because who knows better about management of local affairs than the people who are doing it? And so just having a voice at the table. But right now, I mean, for the most part, it's real tough. It's tough. And you just have to beg and threaten. And I heard the speaker at lunch say it's become very divisive. That I would agree. So.
Yeah, local solutions to local problems. That seems to me to catch the essence of the benefit of the home rule board.
And I think certainty too. You heard the lunch speaker say, what the heck is a matter of purely local concern? Who knows? But now Ryan can say, well, the home rule board says I can do this. So.
I don't have a question. It's on too much. But I do have a comment or a clarification. Berkeley County, at least, would like very much to have home rule. And it's not because we just want the 1% sales tax. We'd like to do some of the things that we think we could do for our county that the legislature maybe has given some authority to do, but counties have very limited revenues. So we, along with that, probably would want to use the home rule to get a revenue stream, but it's not just to have that money for things that we already do. We'd like to have some money to do things we cannot do now because we don't have the revenue to accomplish it.
Well, and I'm with you, and I think you need to talk to the Association of Counties and the Association of County Commissioners and see if you can move it forward.
Yeah, I think the Eastern Panhandle is the classic case of a region of the state that has issues totally different from the rest of the state. I mean, we're not concerned with urban sprawl in McDowell County. And you just have a different set of issues, and of course, home rule would make a lot of sense for the eastern counties, or even the Potomac Highland counties are totally different.
And that's part of the problem we've had for a long time. The overwhelming number of legislators don't really recognize that the Eastern Panhandle exists, much less that it has.
You keep trying to
different
succeed.
Other questions? Okay, there we go.
I guess this may be directed towards Ryan, but I'll say I don't know much about annexation. I live outside of Morgantown city limits. I just see signs everywhere I drive in Morgantown. But now that I know about this 1% sales tax that the city of Morgantown can get, I mean, is that one of the driving forces behind why why the city of Morgantown is trying to annex all these additional businesses and, I mean, create a bigger revenue stream? I guess, what is annexation, if that has any play with home rule? What does that do to benefit the city of Morgantown?
So annexations, particularly by minor boundary adjustment, have been a recurring issue between cities, county commissions, and the residents adjacent municipal territory throughout West Virginia, and pretty persistently over the past 10 years, at least. Definitely before that too, but it is, it's partially a function of just providing efficient services. When a municipality has boundaries that are not uniform, it's required to cover a large service territory, but it's covering areas that aren't contributing on the same terms to the provision of those services. So I think there are various, there are inclusive community reasons for it. There are certainly fiscal reasons behind it, although the analysis of the fiscal impacts in terms of the additional revenue generated and the additional cost of services provided are really kind of difficult to know up front. It's not purely an attempt to gain additional funding. And in general, the sales tax doesn't tend to play a lot of role in that. The opposition is often driven by people who would be impacted by additional business and occupation taxes or property taxes by being included in the boundaries. Now, and you know, I've been talking about West Virginia municipalities generally. Just to be clear, Morgantown doesn't have a current application for a minor boundary adjustment annexation. There was one in the last term of council, but that's not currently an initiative that's being put forward.
Yeah, I would say on Morgantown's annexation rationales, the current boundaries of Morgantown are completely irrational and need rationalization. For example, the residential community across from the stadium is not in the city. Milan Chemical is not in the city. Mon General is not in the city. That residential community behind North Elementary is not in the city. On the other hand, the city did reach out and grab Walmart a couple years ago along Interstate 68. And if you ever see the boundaries of Morgantown, you can look at it and it looks like it's worse than what is that, a Rorschach test, or is that what it's called? I mean, it's completely irrational. And if you listen to the speaker at lunch today, who spoke about North Carolina annexation, which in fact was probably the most liberal annexation program in the country for quite a while, and was much applauded by urban experts, particularly Rusk, the former mayor of Albuquerque, who has been advocating liberal annexation laws. And one of his primary examples of the way to build cities was the way North Carolina did, and the tremendous progress that had been achieved in the Research Triangle area and in other North Carolina cities who prospered because of easy annexation. And it brings certain advantages with it. And David Rusk was the former Albuquerque mayor who's written about this. And the more difficult you make annexation, the more you sort of hem in cities and make it more difficult for growth. So there are a lot of reasons why we shouldn't be tightening our annexation laws like the legislature did this year rather than liberalizing them, in my opinion. And we did, I think that bill passed, didn't it?
So Jared, do you want the last question? All right, yeah.
Better than repeal, but still not that good.
All right, so if I know Jesse well, he's already planning the next Home Rule Symposium for 10 years from now.
Actually, next year, Aaron.
What do you guys think, or what do you all hope to be discussing about the Home Rule pilot program, or just Home Rule in general in the future here in West Virginia?
That was going to be my last question anyway. What's the future of Home Rule in West Virginia and across the country?
Well, across the country, I would say it's growing, and this has been fairly steady. You know, Home Rule started, well, most people say Home Rule started in St. Louis in 1875, and that form of Home Rule took root and quickly expanded and then ran into judicial hostility, and then we went to a different kind of Home Rule, which is now probably the most prevalent. I would hope, I can't predict this, I would hope that in West Virginia we would find a more receptive judiciary to what we have, and that we'd finally become enlightened about municipal power in our courts. I have no indication that's going to happen, but I would hope that would be the case. I think that would ease a lot of our concerns about the scope of municipal power. And I think we need to look at local government revenues in the state, which are both complex in their explanation and in their solution, but they're clearly a major problem for local governments. And I would like to see a loosening of 815A in terms of the prohibited subjects. Some of them make a lot of sense. I mean, some of them are just statewide subjects, like we don't want cities granting divorces. I get that. Some of the exceptions relate to good government, and that seems appropriate, that you can't have cities qualifying open meetings laws and FOIA and so forth. So the fact we have, what, 23 exceptions, I think.
30. If you count, there's multiple ones in some of
Oh,
those
okay.
sections. 30.
Um,
I counted last night.
I mean, obviously guns, I mean, what are you gonna do in West Virginia? But some of the exceptions make sense and aren't not major impositions, because I think cities would go along with them anyhow, like the good government provisions. But I think some of the others we could loosen up.
Yeah, I think to pick up Professor Bastress's point in his discussion about the pushback, the restrictions on municipalities have resulted from a lack of trust of local government. I think that this program, especially as it expands to more communities and smaller communities, is a way to build that trust. Because I think that the initiatives that have passed and been implemented have been based on broad support in their communities where they've been brought forward. And so because of that, there haven't been a lot of people upset, particularly about initiatives that were approved through the Home Rule program. And so if this program is just a long-term mechanism of learning that we can trust local governments to be both responsive and responsible with those authorities, then maybe the conversation in 10 years is about how that distrust is less of an obstacle, and those additional powers to manage their affairs are kind of expected of governments, and more responsibility is expected of them as well.
In 10 years, I'm gonna still be talking about Judge Dillon. But we have a break.
We have a break. So thank you to our panel.
You don't want the veto?
We do have another break. We'll start again at 2:50. This is the last real break before, so there will be a panel and a speaker at the end, and those are butted right up to each other. So if you need a break, please take it. Again, if you're here for CLE credit, please check in with the CLE table. And if you're going to head out between now and the end and you needed CLE credit, do not forget to stop by the CLE table first.
Professor, thank you. came, and then he decided that the best thing in the world for him to do was like some sort of land, I can't even remember what it was, but it was an initiative that he wanted to do, and he went to the mayor and he said, you know, I'm the guy, you know, we ran against each other, but it's over, you won, and I want to help you, and he said, he just said, are you out of your mind? Get out of my office, I don't want to talk to you, and he said, you know, he left there and went, I don't know what to do, I'm just gonna start my own thing, and then he said, you know, punchline. Best thing I ever did. I went down. I did that down there. And so, I'm with, I don't know if you know, Bill and Jesse Forbes. I don't know if you know those guys. I mean, Bill was a prosecutor in Vermont County forever. He's kind of, it's not, it's kind of. But his son is a really good man. Really, really good man. Anyway, I know that family. And my mind kind of is kind of political beating. Just because that whole election was really nasty. I tried to stay out of it. It's impossible. Democrats are mad at me. Republicans are mad at me. Republicans mad at me because I'm Democrat. Democrats mad at me because I worked, because I was representing the Republic. I mean, it's just, and so I left. I mean, that's what I ever thought. I left. I did not take a breath. And so I went over there to Bill Jesse. Just kind of started stuff, trying to pick up some, done a little bit for municipal. I mean, everybody needs to, they're like, you know, I mean, that's where, you know, it's just, you know how it is. I mean, they're like, get someplace to chat. So there's that, you know, but I actually, one thing that I did a couple of things. One of the things, the first thing I did this year, on municipal law was I worked on proposed alternatives to the repeal of the motor I got a phone call, and I kicked over to me, and I put together some proposed legislation that addressed those issues that those groups, who the lobbyists were putting out to everyone, saying, this is why it's awful, and I put together some legislation that I thought addressed. I don't know what it all, but I was being told, they're repealing. And so I put some stuff together, and we picked some of it up, and then basically we got to get consent.
Work the other way.
It doesn't matter.
I just threw him down, like, whose stuff is where. So, it's all good.
I appreciate it. I'm always available for a meeting. I mean, you got a whole law firm now, plus the smartest guy around, so, but if there's anything I can help with, I mean, I'm available. I'm confident now. Let me just, I need it. Huh?
Heidi, nice to meet you.
Yeah.
That's amazing, because my
Yeah, I said I
computer
would.
died last night, and I couldn't download it, and I just figured if you had it, I'd use it, and if not, I'd ditch it. I could go either way. But you're a hero for having it.
There you go.
You're open to view files.
Genevieve also.
Okay, good. Good, I was like, I've been here for a day and a half, and I'm like, no one's used to that.
I kind of walked into it when I sent out that email, because I just thought,
I had this.
my default is always, my default is always,
Don't do them.
we do that, that's the way.
That's me, same thing.
And so I sent this out, and then I think, then Austin's like, well, no, I told them they didn't have to do PowerPoint, so I felt kind of bad.
I just went, even though he said you didn't have to do them, I do them anyway. I always figured that like it just isn't out for people who really don't want to. It's just a habit now, you know, like I do it all the time. It helps me kind of organize myself.
I agree.
But I don't have to use it, you know, like
I'm PowerPoint dependent, I'm afraid.
if anyone doesn't want me to.
Just throw yours in.
Isn't that the slideshow? Okay. All right. Thank you. Now, so I have like super bad sight, so I would love to control it from this. Can I use this to control it from?
Yeah, does that work?
Yeah. It should. I have the.
Oh, you got the thing. Oh, great.
Let's just make sure it.
Yeah, so you could just sit down, right?
That'd be great, just because I'm not standing so great right now.
Yeah.
I can stand if I have to. It's no big deal. Oh, wait a second. Oh, I got it. It's working fine. Yep. Good, thank you. What? There's nothing unfair about it. Why is it unfair? I was just saying.
We did pretty well the last one.
Okay, just tell me how much time, because I'm terrible. Like, literally, like, use them like a pull me out.
We have an hour and 20.
So I get no more than 20 minutes? 15?
No more than 20 for sure. 15 is, between 15 and 20. If we do 20, then we've only got 20 minutes for Q&A.
Okay, that's totally fine. Just,
Yeah. And I'll just come back, or you can say next one, so I'll just start kicking.
just do something brutal and I'll stop. I always go
Shut
over.
your microphone off, how's that?
That's fine.
Yeah.
That's totally fine.
So they should have done a debate the other night, no kind of debate, they just shut their microphone off.
So I didn't see that one.
It's a food fight.
I didn't see it. I've heard it was
They
awful.
just totally lost control, they were just yelling over each other.
Which is how it's been the whole time, but
I
this
thought
one was
that
particularly
worst.
bad.
That was what.
I didn't
I
get to.
could not believe it.
I've seen several of them, but I didn't
literally
see.
just think you need to just say, okay, we're gonna just shut off your microphone.
With everyone, isn't there an actual time?
Earlier sessions yesterday sounded really interesting, and it's been through the like schedule-wise, like hi, schedule-wise. Yeah, it's kind of neat, and I mean, I feel like today is more, you know, the next meeting will be 50 minutes long, and I came over sick class, and it was like,
Oh, yes, I am. I'll just get it. Yeah, I'll pull it up for you. Yeah, I'm happy to stay here.
Yeah, it feels a little less.
You can throw stuff at me?
All right, while we're getting situated here, I'm Lauren McCartney. I'm the CLA director here at the College of Law. A few of you have approached me to ask about ethics credits. Because this seminar does not offer any ethics credits, we are going to offer us a discount on if you'd like to supplement your seminar with some ethics credits from our digital package. So just go ahead and pick up a sheet out from me, and you'll have a discount code there. So thank you.
I guess with that, we're ready. Welcome to this afternoon's panel. I'm Jamie Van Ostrand, the moderator. The topic of this panel is home rule and the environment, exploring how municipalities address environmental policy gaps, including farmland, solar policy, and pipeline routing. And we have 3 presenters today, participants. After they do their presenting, we'll have a discussion. We're going to start off with Sarah Fox, who's going to be talking primarily about state preemption of local environmental efforts, in particular instances of state preemption of local action where no state regulatory framework exists. Sarah is at the Northern Illinois University Law faculty. Her primary research and teaching interests are the intersections of environmental law, property, and land use. Prior to that, she was at Georgetown, where she received both her JD and LLM. After Sarah, we're going to hear from Heidi Robertson, who's the Stephen W. Percy Distinguished Professor of Law and Director of Student Success at Cleveland Marshall College of Law at Cleveland State. She holds a joint appointment there with the Cleveland State University's Levin College of Urban Affairs, where she is Professor of Environmental Studies. Heidi's going to be presenting on a case study for local governments in influencing natural gas pipeline permitting, the importance of borders. And presenting third will be Genevieve Byrne, who's with the Farm and Energy Initiative at Vermont Law School and part of the Institute for Energy and Environment at Vermont Law School. And she'll be presenting on state versus solar siting authority. Genevieve had her JD from Lewis and Clark in Portland. So with that, let's start off with Sarah.
Great, thank you. So the way I think this panel is going to go is I'm going to present much more of kind of a high-level overview of some of these issues, and I'm very interested to hear about the more specific examples. But what I'd like to talk about is this kind of idea of preemption of local ability to act on environmental issues, especially where the state has not engaged in any type of action. So it's a very specific kind of preemption, but it's one that I've already heard about in some of the preceding discussions and certainly at lunch, right? This idea of the fact that it might be a little bit different, right? That there's something different about local governments acting in the absence of any kind of state or federal action. And the reason I think it makes sense to look at this coming from the environmental law perspective is that a lot of times if you dig into kind of environmental law literature, you look at kind of the story of environmental law, it's often presented as a story of gap filling, right? There's kind of the early history where local governments would act in terms of zoning, other kinds of forms of common law remedies to address environmental problems. States stepped in to a certain extent to do that as well, but then overwhelmingly, right, through, for various reasons, those were not ultimately enough to address the kinds of complex environmental issues that were starting to arise. And that's where we see kind of the advent of the federal environmental law statutes coming in the 1960s, 1970s, to fill in some of those gaps to help kind of achieve greater environmental protections where there were failures at the state and local level. And for a while, that's predominantly where we saw environmental law action taking place, right, is at the federal level. Certainly with some delegated authority to the states, right, a lot of cooperative mechanisms, but by and large, looking to state and federal actors to kind of address environmental problems. Now, obviously in 2020, right, that landscape looks a little bit different. We have a federal government that has been pretty willing to, either deregulate or to kind of devolve a lot of authority to the states. We have a lot of states, right, that have not been particularly interested in acting on environmental issues, particularly some of the complex issues like climate change. And at the same time, right, we have local governments that are, in fact, doing a lot of work on environmental issues. And that's why I'm so excited to hear about some of these more particular examples. But, just broadly speaking, right, we see that in the areas of fracking. We see that on the issues of things like plastic bag bans. We see it on a lot of water issues. We see it on a lot of kind of other many environmental issues here, things like climate change, right? that local governments are in fact stepping up and trying to, again, fill in what I would characterize as kind of a gap in authority, in kind of environmental protections here. All right, so obviously, we're talking about this in the context of home rule, right? And so it's not just enough to kind of look at, well, the fact that local governments are acting, right? But it's also that interaction between the local governments and the states. And I know it's not surprising to anyone in this room, right, to hear that, in fact, as local governments have started to act on a lot of these environmental issues, we've seen states stepping in to remove their authority to do that, right? Not only by asserting, kind of, or putting in place a state regulatory scheme, but in fact by just taking away the authority of local governments to act on those issues. So, for instance, kind of the classic example I always rely on is the plastic bag bans, right? Because I mean, to me, at least, it seems like one of the most clear-cut and kind of egregious examples of this, where we see, cities across the country, either imposing a fine or just a ban on the use of plastic bags, plastic containers, and states then stepping in to say, no local government in this state, right, may enact such a ban or a fine, right? It's very clear-cut. The only thing that legislation is doing, right, is removing authority from the local governments to act. Okay, so, from one perspective, right, maybe that's just politics in action, right? Maybe that's just the way that home rule works, right? Certainly states have a great degree of authority to take away local power to enact, a variety of mechanisms. But I also think it's worth exploring a little bit more what those forms of really deregulatory preemption mean for the way that environmental law is going to function, right? Because if you do look at it from kind of a home rule lens, maybe there's not that much to say about it in some ways, right? I mean, you can say, that it's maybe outside the spirit of home rule, right? That it's not really what home rule statutes were designed to do. But from the other perspective, again, home rule, it makes available these broad preemption measures, right? And it's not really outside the bounds of that necessarily. But I don't think that that means that it's not worth kind of thinking about, again, in terms of the broader ways of what that means for environmental law and environmental protections. All right, so if we think about it from that perspective, right, I think that it becomes possible to bring local governments into the broader conversation of things like environmental federalism, right, that they have not necessarily been part of before. And that's what I'd kind of like to propose as kind of a new perspective to add here, is that we start thinking about the ways that preemption is actually impacting the ways that environmental federalism, environmental governance are kind of going on in the country. Because again, if we think about it, if we kind of take this more classic narrative of gap filling, it's really eliminating part of that ability to fill in gaps in some pretty substantial ways, I would posit. All right, so if we, obviously that's going to require digging a little bit into, what is environmental federalism more broadly, right? At the in the kind of classic presentation, right, federalism is of course describing this dual authority, allocation of authority between the federal and the state governments. We don't see an explicit role for local governments within the Constitution and within the classic federalism conversation. But another reason that I think environmental law has something to add here is that just hasn't been the case historically in the context of environmental federalism. So if you look at kind of the conversations about how does environmental governance work in the United States, how does environmental federalism work, you see that it's never just been about this kind of allocation of roles between the federal government and the state government. It's been focused on a much more dynamic relationship among those governmental levels. And so you see discussions of cooperative federalism, of things referred to as dynamic federalism, and really emphasizing again that need for different levels of government to step in at different times to fill in these regulatory gaps, getting at this overall goal of kind of environmental protection, or at least the ability to discuss these avenues for environmental protection. All right, so if we're then in a world, right, where we have one level of government that's just essentially cutting off the ability to play that gap-filling role, then we need to start thinking differently, I would argue, about how environmental federalism actually plays out. And I think that's important just as kind of a reality check, right, in terms of thinking about the possibilities for environmental protection and environmental law. But I actually also think it's important because it might offer, I think our lunchtime speaker suggested that we need to give judges something to go on, right? That there's a need to point to something outside of home rule statutes if we want judges to be able to conceptualize why it matters that local governments are losing authority and why it matters, right, that they should be maybe focusing on or be willing to give a bit more deference to local governments. And I think that this is maybe a way to at least offer them a reason to do that, right? Because it's certainly well within the bounds of kind of the federalism conversation for judges to focus on that, right? To focus on the ideas of federalism as a reason for preferencing one level of government versus another. And that may be the case here as well. So to dive into a little bit more what that would mean, again, if you kind of refer to the environmental federalism conversation, what that conversation focuses on mostly is the idea of federalism, again, not as kind of two dual entities, but on really a governance mechanism that gets to certain values, all right? And so if we start thinking about the values of federalism, those vary from discussion to discussion, but are generally focused on things like accountability, experimentation, voice or participation, and really aimed at kind of getting at what level of government, right? Assigning authority to what level of government is really going to get us to the attainment of those federalism values. And again, I think if we look at federalism, or environmental federalism at least, from that perspective, it becomes clear that taking away authority from local governments to act, particularly when there's no action at the state level, is going to undermine some of the ability to get at certain of those federalism values. And again, I think this is certainly true across the board, but I think environmental law offers a really good way to kind of look at the kind of impairment of some of those values, both because that's already part of the conversation here, but also because there is this kind of broad tradition of participation at the local level, the state level, and the federal level. And there's just recognized interest at all of those levels as well, right? So environmental law has always been something with a strong local interest, a strong state interest, and a strong federal interest. And that's part of the reason that it's been such contested territory over kind of who gets to dictate what environmental protections are going to be in place and who gets to decide those things. All right, so, all of that is to say, I think that environmental federalism offers a new lens to get at what I would call these kind of regulatory gaps or regulatory vacuums put in place by certain forms of kind of deregulatory preemption. If we start looking at that then through the context of, how do judges normally assess this kind of preemption, right? Again, I don't think it's any surprise to people here that in the context of state and federal preemption, there are certain protections in place for state actions, right? There are things like the presumption against preemption that is often used by the Supreme Court and other courts to avoid kind of finding that a federal statute preempts a state statute. That's not present, right, in the state and local context, at least as how home rule statutes operate currently, right? But it is a protection that kind of operates at that level. We can see other preferences kind of against these forms of regulatory gaps. If we look to things like tort law, again, where the Supreme Court has explicitly kind of, construed statutes to avoid these kinds of regulatory gaps. And we can also look to kind of the court's conversation about when and why these kinds of regulatory gaps are going to be allowed. Looking to things like the fact that sometimes, federal preemption of state statutes is going to be allowed because, we think that states are adequately represented at the federal level, right? Or because we think there's a certain amount of policy or process that's in place in the passage of federal statutes that'll provide certain protections. And again, those things aren't necessarily present at the state and local level, right? In the context of representation, there's been an enormous amount of conversation around gerrymandering, right? The fact that a lot of cities are not actually adequately represented at the state level. And on the question of process, there's actually been a lot of research currently going on that I believe is going to be published soon about the kind of lack of process that goes into some of these state statutes also preempting local functions. So if we look to all those things, right, again, we get to this idea that what's happening here is maybe fine, on the surface within the context of the home rule conversation, but it's troubling in the ways that preemption conversations have occurred in other contexts, and it's troubling in terms of getting at the actual values of environmental federalism and perhaps federalism more broadly here. So my proposal would be to kind of start rethinking a little bit about how we think about environmental federalism and governance, and how to bring local governments into that conversation a little bit better, okay? So to do that first, I think, first of all, we just have to recognize that in the context of environmental law, local governments provide certain benefits that states don't necessarily, right? Particularly within the context of these federalism values, perhaps more broadly, right? So if we think about what it means to have, certain environmental issues going on, often, right, those are very kind of local in nature. They're at once maybe local in nature and more broad, but there's specific local conditions that are being responded to, right? And the nature of environmental conditions is that across the state, those conditions are going to vary widely. They're going to vary in terms of kind of the density of population, but they're also going to vary just in terms of, where the water supply is, or what the groundwater conditions are like, what the soil conditions are like, right? There are these kind of hyper-local environmental conditions that make it necessary for local governments to respond in ways that might not apply statewide. And if we think about those again in kind of the context of federalism values, it really gets at this idea of experimentation, right? How are we going to solve these kind of diverse problems? Maybe that part of that is by allowing local governments some room, some breathing room to try and address those things. It also goes to this idea of accountability, right? Voters want, officials in office that can respond to their specific concerns. And this is one way to, that they are able to do that. And I think it's worth pointing that out because a lot of times kind of the value of state action and the value of local action are conflated a little bit, right? There, we kind of refer to states as being able to provide this experimentation function, this kind of accountability function, when what we actually mean is that local governments are providing that, right? That the experimentation that's actually going on is the local governments within the states. And within the kind of state and local preemption context, I think it's really important to kind of parse, who is doing that kind of experimentation and who is playing that role. All right, so if we acknowledge that, right, if we kind of acknowledge for the minute that local governments are providing something distinct from states, then I think step 2 is acknowledging that by kind of engaging in deregulatory preemption, by taking away the authority of local governments to engage in some of this experimentation and these actions, we are actually harming environmental federalism values, right? And we're doing that, I would say, by creating these kinds of, again, what I would call maybe regulatory vacuums or regulatory gaps, right? Areas where that kind of experimentation is no longer going on, right? And that, again, has been disfavored in a variety of contexts. And I would say it should be disfavored in the kind of state and local context as well, even if it's allowed, right, under kind of home rule frameworks. I think there are broader reasons for kind of disfavoring that. I think there are reasons, right, for thinking about the kind of impairment of federalism values, again, from the experimentation front, right, for what it's going to do in that context. I think there's even reasons for thinking about it and disfavoring it from the environmental justice standpoint, right? There's a lot of times when local communities, especially communities that have been more disproportionately burdened by environmental harms, are working to address those harms, and taking away the power to allow them to do that is going to undermine kind of the attainment of some of those environmental justice benefits, and it's going to undermine that, therefore, kind of some environmental federalism values as well, because justice is really, and equity is built into that framework. All right, so then what do we do, right? We acknowledge that. We acknowledge that, yes, there's benefits from local governments. Yes, we might be impairing federalism values. And I think what that means is that we need to start having much more localized conversations about how environmental federalism and how environmental governance is actually playing out across the country, right? It's not possible necessarily to have just national conversations about what environmental federalism, what environmental governance is, because it varies so much by state, by home rule framework, by kind of the various preemptive measures that are in place there. And that allows us to have much more realistic conversations, I would say, about the potential for local action on things like climate change, right, which varies widely across the country. And it also allows us to point out maybe to judges even where those values are in danger, right? Maybe that's something that can be brought up even in the context of litigation as sort of, just a more policy argument for why this kind of deregulatory preemption is harmful, even if allowed under home rule frameworks. So I think that's all I will say for now, but I'm very interested to hear more explicit examples of kind of this undermining of local authority.
Okay. Next we have Heidi Robertson.
Let's just make sure this. Okay, so you've been, is this on? I don't think I need it, do I? I'm good? Okay, so you've spent a day and a half looking at faces with no pictures, and I'm here to break that cycle I apparently did not get the memo that that we weren't using PowerPoints. So neither did our fearless leader, who asked us to send stuff. Okay, so you've heard a lot about what municipalities can do with the benefit of home rule, what they cannot do, even with home rule, and the role of preemption when home rule doesn't protect the municipality when it acts in a space where the state prevents that action. And I think we've heard a couple of themes. One is some frustration on the part of municipalities when they would like to act, but home rule isn't broad enough, or has been interpreted as being more narrow than the actions they'd like to take. Some frustration there. And Sarah was talking about variations among states. We heard a little bit about that at lunch too, about what all this means varies state by state. So I look into these issues really at the intersection of local government law, natural gas development, and legislation and regulation. I mostly work on issues in Ohio, but often comparing Ohio to what's going on in nearby states. And in particular, I'm looking at what local jurisdictions and their citizens can do to achieve their intentions or their goals in the face of preemption in the broader context of what should be home rule. So let me start by telling you briefly how I got here. And that is, I've written a few articles on related topics, and I'm just going to kind of quickly tell you why it's related to what I'm doing. The first article in this little series that I've been doing is about state variation in local control within a shale region. And that has to do with local governments that want to have an influence on oil and gas decision-making. I'll talk about that in a second. The second is on landowners who want to avoid drilling beneath their land, and landowners, obviously, some of them are local governments, and what authority do they have there? And then this article is really a case study about local efforts to influence natural gas pipeline routing decisions. So I'm going to just talk for a minute about the first article, because also it kind of gives you some background about Ohio. This one is about state variation in local control of oil and gas decision-making within a shale region. And it really focuses on that these variations are tied to key differences amongst the states in three areas. And kind of the big point there is that borders matter enormously in what local jurisdictions can do. I'll come more back to that later. But the three areas within a shale region that lead to local jurisdictions having completely disparate abilities to control oil and gas related decision-making, obviously are what is the state constitution under which that local jurisdiction is operating? Is there a home rule provision and or an environmental rights provision at play? Second, state legislation. Is there preemption, either by broad subject area or specifically directed at whatever the local jurisdiction is trying to do? And third, what are the possibilities with respect to local ordinances having to do with location or permitting or zoning? So this article looks at sort of three states within the same shale play and analyzes the differences in these three areas and their impact on the ability of local jurisdictions to regulate, sort of resulting from differences in these areas. I'm going to skip this second one because there's not enough time really. But what I'm working on now is this third piece, which is looking at including local governments' efforts to influence natural gas pipeline routing in a context of a constitutional home rule state where the legislature has by statute specifically preempted local jurisdictions from taking really any action related to oil and, the natural gas, oil and gas industry. And this project relates specifically or primarily to the city of Greene, Ohio, which is near Akron, and their efforts to influence the routing decisions of the Nexus Spectra Energy pipeline. Greene sought to alter the pipeline's route to an area farther south and less populated. And although they largely failed to do that, I'm going to talk about, this is the circumstance that they're in for a number of reasons, is having to find lots of other ways to influence the pipeline's route because they otherwise don't have any opportunity under the legal context in which they're operating. So these are the three articles. I have two of them here. One of them's not yet out yet because these guys are working on it. Okay, so like I said, Ohio has a constitutional home rule where the local jurisdictions can't contradict or impede the general laws. We've discussed about how vague that is, and local jurisdictions want to and have passed in Ohio ordinances and charter amendments attempting to ban or control oil and gas related activities. Not many have been challenged, but those that have been preempted by the state oil and gas law, which gives sole and exclusive authority to the Ohio DNR to regulate in that space. With respect to pipelines, it's a bit more complicated. I'll say it's a lot more complicated because they are controlled by the Federal Natural Gas Act, which, in terms of federalism, leaves to the local governments, not local governments, to state governments, the decision-making authority with respect to sort of subsidiary permits that have to be made. So where does that leave local jurisdictions? They're hoping to act successfully according to the interests and wishes of their constituents, their residents, with respect to where this pipeline will run. Some of the problems they face include federal law controls interstate natural gas pipeline permitting, and it is super complicated. State law often, and certainly in Ohio, heavily favors the utilities. And state law in Ohio preempts local efforts to influence or control these activities. So this study looks at what has Greene done to try to influence the pipeline's location, sort of in that context. Here's okay. I think I did. Yeah, that's what I'm looking for. There's your first picture. That is where the pipeline route was proposed to go, and if I can make this thing work, the little light. Oh, it's pretty dim, but there's Greene, and Greene is, that dot is the center of Greene, but it actually extends pretty far. It's a pretty big suburban area outside of Akron. A little bit more about the pipeline. This is a natural gas transmission line that was proposed to span 255 miles across Ohio, Michigan, and to a terminus in Ontario. And they had the rationale was to meet an alleged desperate need for the growing natural gas production in Appalachia. So, to influence the route, it's important to know a bit about the process. Really, their focus was, where is the pipeline route going to go? In terms of getting it approved, before you can get permission to build a pipeline, you have to have the route approved And it has to go through an extensive pre-filing and filing process that includes route approval, review of new lines, environmental assessments, and coordination with a number of federal and state agencies. And all of this matters to local jurisdictions, so let's see what kind of influence they might have in this complicated process. Okay, so with respect to picking the pipeline's path, it involves the pipeline company coming in and evaluating existing maps and studies, sometimes doing their own. They'll have to conduct community meetings, and in this instance, Nexus sent out letters to citizens and to local governments inviting participation in the selection of the pipeline's route. They also had to carry out surveys having to do with engineering needs, civil engineering, cultural resource locations. There's geotechnical surveys and environmental related surveys that would fall into the Federal Energy Regulatory Commission's responsibility to do the environmental review as required under the National Environmental Policy Act. Some of those surveys required entry onto private land, which if I skip 2 ahead, you could see people didn't really like the entry onto private land. And this is what they thought was going to happen, that the pipeline was going to go right through their house that says, we're sorry if it causes you any inconvenience. Okay. So the process is governed by Section 7 of the Natural Gas Act and is overseen by FERC, the Federal Energy Regulatory Commission, which oversees the permitting process and acts as the lead agency under NEPA. That matters because of the public involvement opportunities that NEPA provides for local landowners, local governments, and other stakeholders to be involved in all of the information gathering and decision making that happens in that process. Lots of environmental permits are required on the federal level. NEPA, I won't go through them all right now in any detail, but for just as examples, National Environmental Policy Act, the Clean Water Act is involved here. Obviously, at the federal level, it's a federal law, but state water quality certification happens at the state level. The U.S. Army Corps of Engineers is involved. At the state level, there may be NPDES permits required. So it's an example, again, of environmental federalism. Coastal Zone Act, Endangered Species Act, National Historic Preservation Act, all of those may come into play, and they have various degrees to which there are opportunities for public involvement in those processes. But at the center, at the heart of decision-making is FERC, or the Federal Energy Regulatory Commission. If you're the local government and you want to be involved in influencing where the pipeline goes, there are other places where you might find opportunities for influence. One being the Ohio DNR, Department of Natural Resources, that's responsible for reviewing natural resources implications of the pipeline's route. Ohio EPA, which is responsible for the water quality certification permit issuance. As I mentioned, the Army Corps of Engineers, but you'll note that there are no local requirements or approvals are allowed in this process. So local governments can't get involved by issuing permits or additional requirements. I'm going to skip that because there's several lawsuits going on as we speak about it. But so I've been focusing on the city of Greene, Ohio, and what they've been doing to try to influence the pipeline's route. But also involved and challenging the route have been the cities of Oberlin, Bowling Green, New Franklin, and others. And the kinds of actions they've taken include things like passing an ordinance. New Franklin passed an ordinance banning oil and gas activities. Obviously, that's preempted in Ohio. You know, knock yourself out, but no. Bowling Green passed a charter, an amendment to its city charter banning oil and gas activities. Again, okay, preempted. All of the city councils involved have passed resolutions of disapproval. Thank you for your thoughts. There have been, they were all involved in meetings with the Ohio EPA chief trying to influence the Ohio agency's issuance of the water quality certificate, basically saying if you refuse to issue the water quality certificate, they can't get their pipeline permit, right? That was unsuccessful, and there have been a lot of lawsuits involved. This is what Green wanted to do, was move, I think my little light is past its prime, but you can see the route that they proposed is red, and there were two, there was, their alternate is the blue down there, and then there are some existing lines that are indicated, but really what they were trying to do is move the line south. And they submitted this proposal to FERC, and FERC just elected not to require Nexus even to study this plan. So that also was not effective. Green tried to negotiate with Nexus over the pipeline's route to try to get it to move, as I said, to lower population density areas, and Nexus initially agreed to make some small changes in the route, but the electric utility, First Energy, opposed that agreement, saying it was going to be in the way of its high power lines. So they weren't, Nexus tried to get Green to transfer easements voluntarily to Nexus so that it would very easily be able to get access to the pipeline's route. They did this by saying, here's what we believe these easements are worth. They were really just forms calculating the easement values, and Green said, no thank you, that doesn't sound like an offer to me. That sounds like you're just some useful information. And then not hearing from Green on their easement valuation forms, Nexus sues Green over the easements. Green participated in all of the administrative processes, attending FERC meetings. Interestingly, I had a long meeting with the legal department at Green and to try to understand their involvement in the administrative process, and they unanimously agreed that they had attended many of these meetings, and some of them that were supposed to be public meetings, there was nothing actually happening in the public meeting room, but people were going back one at a time into some back room for a discussion, and they weren't invited. Green sought to prevent Nexus, as I said, from getting its 404 permit, the dredge and fill permit under the Clean Water Act from the Army Corps. It sued it first appealed the issuance of the 401 water quality certification, filed an appeal with the Environmental Review Appeals Commission, all unsuccessfully. The Natural Gas Act gives them leave to directly petition to the Sixth Circuit. Yes, they tried. They tried using their own local ordinances, filing stop work orders in a number of areas. Nexus sued them on eminent domain grounds. Any case, there were a whole bunch of cases got consolidated in the Northern District of Ohio. And when the Sixth Circuit ultimately set a date for oral argument, it was actually going to hear some of these cases, Nexus offered a settlement to Green. I guess I'm behind. So everybody was suing. Green sued everybody in trying to get some positive response on this moving the pipeline. These are some of the parties they sued. Now the primary result, it's not so good when this is behind you. The primary result here is that Nexus did ultimately FERC ultimately did approve Nexus's request for what's called a certificate of public convenience and necessity, which is basically permission to move forward with the rest of the process. Interestingly, the Nexus issued its notice of commencement of construction, saying that they issued it on the 17th. It was a day late, but there it is. Let's miss this and this. That's what it's gonna look like. So in terms of what the local jurisdictions were able to achieve through this massive, broad, inclusive, extensive effort to try to use all of all of the other resources available to them, aside from what they thought they might have had through home rule, or was they got nowhere on the routing decision, but they did get a settlement from Green, and you can see up here what Green got. It was a very narrow win on the Green City Council in terms of approving it, but it did bring the city $7.5 million, in addition to some land that was purchased on their behalf to expand a park, and some assurances with respect to safety and monitoring of the pipeline, which have already to this day come in handy. And Green got what it needed, dropping lawsuits, got the easements. I'm almost done, if that's what you're about to tell me.
No, I'm making notes.
Oh, okay.
Fine.
Okay. I go on too long. Okay, but so this settlement that Green got, which to me appears to be about the best they could have done in light of the circumstances. The residents of Green were furious. They were livid. They thought the city had just failed them. And, you know, so you could see one of the quotes from one of the Green residents: "Not at one time did the city control the process of where the pipeline would go. Everyone, residents of Green, have a right to be angry." Really? You know, you're right. Not at one time did the city of Green control this process. The city of Green had no hope of controlling this process. And ultimately, the mayor says our options have run out, and by a very narrow margin, the city council passed the settlement. The law director was basically ousted from Green as a result of this, even though I believe it was the best result she possibly could have achieved in light of the circumstances. So what do we learn from Green's efforts? One, that law, history, and the administrative process are all on the side of Nexus Spectra Energy. As far as I know, to date, FERC, that no pipeline project has yet been derailed or substantially rerouted post FERC approvals. You know, in this Ohio case study, what I saw is lots of cities participated in the administrative processes and in the legal processes, and through lobbying efforts. I said they all went and met with the Ohio EPA. They participated, they opposed, they sued, and they lost. But I think that one lesson is that settlements aren't worthless. The city of Oberlin has still refused to accept a settlement with Nexus, and it had been involved in the process all along. At this point, what's on the table for Oberlin is, in terms of what Nexus is offering them, is a fraction of what, you know, Green got $7.5 million. I think Oberlin will be lucky to get $500,000. And they're going to lose anyway. So it's a shame there. So what else can local jurisdictions do? Not good from behind me. Is what we've seen local jurisdictions able to do is create ordinances regarding roads. Those matter to the pipeline company. Pipeline companies will actually contribute to road maintenance and improvement in deals with local jurisdictions that are going through their area. Local involvement can also include the same kinds of agreements with respect to utility use and maintenance. They have some control over easements where they're until the company uses eminent domain to get what it wants anyway. And they can have some involvement through mostly discussion and negotiation of construction and planning, and that's often achieved through using their traditional zoning authority. I want to get back for a minute to the importance of borders. I mentioned it at the beginning when we look at the legal context in various states, looking at home rule, whether they have home rule, how that home rule is interpreted and implemented, and whether or not they have preemption, broad or specific. It matters very much to these projects. Just last spring in May, we saw New York State reject a similar interstate pipeline, and the way it got rejected was because the local jurisdictions, helped by environmental activists, were able to impose upon the state agency to deny the clean water, water quality certification permit. So there you have the state or the local jurisdictions really pushing their state agency with some success. It's still being argued, but they haven't turned this one around yet. It's still been denied. That particular pipeline was a shorter one, much shorter, but like the Ohio Nexus Spectra Energy, it was an interstate natural gas transmission line, so it was subject to many of the same permitting requirements, federal, state, and so it needed the same thing. And basically, what we saw, the difference was Ohio EPA granted the water quality certification. The New York Department of Environmental Conservation denied it. And, I guess I view that as a pretty big success by the environmental organizations and banding together with the local jurisdictions to exert influence on their state agency. But again, that all depends on what you've got for a state agency. Ohio's is very different from New York's. Okay, am I still okay? Okay, all right, I'm basically done. Whoops, I got one more. Yeah, so in terms of next steps, what I'd like to work on is evaluating sort of not just the content, but the quality of local government participation in the administrative processes. I'd like to think about how we can seek increased roles for local jurisdictions in the state and federal permitting processes, because that's where they seem to be able to have some influence. And also to reflect more on potentially useful local actions outside the permitting and judicial processes, that is maybe perhaps focusing on traditional zoning authority. One of our Ohio Supreme Court justices says non-discriminatorily created and applied, meaning not focused on the oil and gas industry, but if you can create local land use ordinances through your traditional zoning authority and have it non-discriminatorily created and applied, it could perhaps withstand that state preemption and be able to stand. Okay. Thank you. No idea how much time I've done. Oh, would you like to use this? Oh, yes, thank you. Would you like a lesson? It has to be turned on.
Now, Genevieve Byrne's going to talk about state versus local with respect to siting of solar facilities. Yes? No. Go.
Little arrows down. Hi, Genevieve Byrne. So just to give you a little bit of background on this project, I am the staff attorney for the Farm and Energy Initiative at Vermont Law School. We're funded by the USDA National Agriculture Library, so all of our work is supposed to sort of be national in scope, and for this program focused on issues at the intersection of agriculture and energy. So we've been looking at solar development sort of through the lens of farmland, both farmland protection and farmer access to clean energy, because it turns out solar development laws can both sort of roll out a lot of solar development on farmland and be a huge barrier to farmers participating when the rules are too restrictive. I also want to say thank you to two students who came down with me, Ludovica and Dan Brown, who've been working on this project for off and on for a couple of semesters.
Point it at the machine, not at the screen. The computer.
Sorry. Next. So these are just some examples of some strife that has come up with sort of local zoning and solar. Various towns passing moratoriums on solar development, or facing litigation over solar development, or needing to sort of scramble to create rules about solar siting once a state passes, for example, a very ambitious sort of clean energy goal that's going to roll out a huge amount of solar in the state. And so solar development seems like something that is a positive, right, that may not have that much impact. And in fact, there are a lot of examples of it being really good for farmers and farmland and supporting farm viability. So why so much strife? This is a land use that really didn't exist before 20 years ago. I mean, in the last 10 years, solar has really exploded. It's very different from the sources of power that we're used to, sort of large centralized sources of generation. It can go almost anywhere, and it is going almost anywhere, which is part of what's creating some of this conflict. We have municipal boards who may be responsible for approving this siting that have very little experience with energy, that have very little experience with solar, that haven't had practice sort of examining the land use impacts of this technology, as in fact not very many of us have because of the newness of the technology. Rapid expansion of solar across the country right now, it's generating almost 3% of US electricity need, 2.6%. That's 71.3 gigawatts of installed capacity. There are also the solar industry itself has expanded rapidly. It's overtaken a lot of other fossil fuel energy sources in terms of new job creation. We had nearly 250 million solar jobs last year, and that's supposed to increase by 8% next year over the 250 million that already exist. I think of solar as limited more by site type than by specific parcel of land. So you need just something that's relatively flat, relatively sunny, and relatively close to the grid to develop solar. And so that creates competition, land use competition for those parcels of land. Really, any undeveloped land is going to be sort of a good site for solar, but it puts a lot of pressure, particularly on agricultural land, often because farmers are in fact struggling to maintain farm viability. And so if you can bring in another income stream by putting solar on your land, you definitely want to do that, and you may want to do that regardless of what soils that land is, regardless of sort of what the long-term use for agriculture, how that may be impacted. Just to give you a couple of examples of the farm viability benefits, up in Vermont, Magnan Brothers Dairy Farm, which is over in Fairfield up near us, put a 150 kilowatt array just on 2 acres of marginal farmland. They receive lease payments to host that array because it's actually a community solar array, meaning that multiple customers or entities, essentially multiple houses, can sort of use the energy that's being generated by that array. And they've said that array helps balance the variability in milk prices. They're at 700 cow dairy farm that actually send some of their milk to Cabot Cheese. And so they've seen a real effect on sort of their bottom line. Larger example, not just in sort of New England, out in Center City, Minnesota, Eichton's Hidden Acres Cheese Farm. They have a 5 megawatt array that's covering 21 acres, again, of identified marginal farmland. And they're receiving $800 to $1,000 an acre for 25 years. They say that's almost doubled the income stream of the farm, and they've planted pollinator habitat in and around the panels, which has been beneficial to other sort of local surrounding farms. That array also powers a local school district, an elder care facility, and some other properties surrounding the farm. So this is all good stuff, right? But creating strife, as we see in the articles. So to take a look at some differences in how states are handling solar siting, we've been focusing a bit on New England, though we are ultimately looking at how all 50 states are siting solar on farmland. And if you look at Vermont, New Hampshire, and Massachusetts, in Vermont, the state has entirely preempted energy generation regulation. So if you want to build any size of solar array, from a very small residential array up to a utility scale array, you need to go in front of the Public Utility Commission and obtain a certificate of public good. In New Hampshire, there's sort of more a divided authority over solar siting, where they have preempted siting authority for large-scale facilities. If you're an array over 30 megawatts, which there aren't a ton in New Hampshire, I just heard that I think like one array has gone through that. One array over 30 megawatts has gone through that process. You're in a sort of Vermont similar regulatory scheme, where you're gonna go in front of the State Site Evaluation Council, receive a sort of similar certificate, and that's in both of those situations, you're sort of rolling in all of the other municipal permits, environmental permits that might have been required of this project. Massachusetts, on the other hand, has a much more municipal permitting process for solar. Technically they do have a state siting board for projects over 100 megawatts, but none of the solar projects are going through that process. And in both Vermont and New Hampshire, when you're talking about this sort of state level siting council, we're really talking about a trial-like adjudicatory hearing where you're going to have pre-filed testimony, you're going to have expert witnesses. And so deciding when that makes sense for a solar array versus when that might not make sense for a solar array, I think is one of the challenges that states and municipalities are facing. Both Massachusetts and New Hampshire do sort of direct their municipalities as to solar siting sort of implementation. They both have laws within their zoning code that saying that towns can't unreasonably regulate solar. In New Hampshire, they pretty much leave it at that. Towns develop their own zoning regulations. You go through the permitting process that's required by the town. In Massachusetts, they definitely do not leave it at that, even though you would look at it and say, oh, I need a local zoning permit to permit my array. They layer a lot of land use and siting requirements into the rates that you can get paid for solar energy in the state. And they also sort of, someone used like punitive preemption. I don't know if this is quite the same thing, but they run a green communities program where in exchange for passing sort of permissive solar zoning, the town can then get grant money, technical assistance, and other help from the state. So even though it's a sort of municipal process, the state really has a huge hand in the solar development policy in both the size, sort of location, and design of these projects. So just to get a little bit more detail on the Green Communities program, the criteria that the towns would have to meet to actually take advantage of the benefits, the grant money, the technical assistance. First, they have to agree to cut municipal energy use by 20% over the next 5 years. They must pass zoning that designates solar as an as-of-right use in at least certain areas of the municipality. They also have to adopt expedited permitting for certain solar projects. Expedited meaning it would take less than a year to get through that process. If practicable, they have to purchase municipal fuel-efficient vehicles for the municipality, and they have to agree to minimize life cycle costs of new construction. So if they do all of that, then they get money, and a lot of the communities really are doing it. 240 different towns in Massachusetts have gone through this process. So when we say it's a municipal process in Massachusetts, it is sort of. Let's go to the next. So this very complicated chart sets out the process in Vermont. Vermont has, as I said, preempted all municipal control of solar siting. So when you go to the Public Utility Commission, they've worked to do some of that decision making about what happens to a sort of really small scale array versus what's going to happen to a much, much larger array. If you're up to 15 kilowatts, this is pretty small scale. One house, if you think of a residential array, it could be anywhere from like 7 kilowatts in capacity, maybe up to 14, 15 kilowatts in capacity. So this is really trying to target those extra small scale arrays, as well as roof-mounted arrays up to 500 kilowatts. Roof-mounted can go through this sort of expedited process as well because they're not having the same land use impact, right? You're putting it up on a structure. If you meet the criteria for this sort of first, easiest, fast-track process, then you're getting your array approved and getting your certificate of public good basically in 10 days. You are deemed approved unless the utility complains that the array is not good it's not in a good place in terms of grid reliability needs. 15 to 50 kilowatts, an application process. That's getting more into the adjudicatory hearing type process, but there are fewer criteria that the Public Utility Commission is going to apply. And then for much larger scale arrays, you go through this whole petition process with all the expert witnesses, pre-filed testimony, stakeholder involvement, public hearings, and the whole kind of rigmarole. They've layered a lot of other rules into the solar siting, the Certificate of Public Good. They do have decommissioning requirements for projects above 150 kilowatts. And if you get much larger than that, then you also need to put up sort of a bond or identify funds for decommissioning. So this is all permitting process. And when you think about why this matters, if I have the same permitting process for a 15 kilowatt array that's supposed to serve one house versus a much, much larger array that might be, could power a whole neighborhood, then my regulatory incentive there is sort of to get the most bang for my buck, right? I am probably incentivizing, even by accident, much, much larger scale development, and I'm actually making it much harder and much more expensive for individual homeowners, individual farmers, individuals to put on those sort of smaller scale arrays. Let's go to rates. So I said that Massachusetts sort of layers all of these siting and land use requirements into its rates. It's even more complicated than the Vermont process, but it's sort of similar, so we're using Vermont as an example. In states that are promoting renewable energy, you often have a net metering program where individual electric customers or communities, groups of customers can get together, put an array, what we call behind the meter, as in that array is going to be sort of powering that house first and then contributing energy to the grid. They can get paid for the energy they can contribute to the grid and then would only pay for the extra energy that they need to take if their array didn't generate enough power. For larger systems, you're often going to have a feed-in tariff or another contract that the state has made available to get paid a rate over the next 10 years, for example. So the states are putting adders and subtractors into these rates to incentivize things like array size and location. So in Vermont, if you have a very small scale array, no matter what location it's in, you get an extra cent per kilowatt hour on your rate. If you're sort of medium sized, but not on a green field, you're gonna get a 1 cent adder. If you're a large scale array and not what's called a preferred site in Vermont, then you're gonna get dinged like 3 cents per kilowatt hour on your rate. Over time, we're talking about 10-year contracts. This makes a huge difference. Also, if you get a negative rate, it doesn't just last 10 years, it actually lasts the lifetime of the project versus the positive rates that apply for 10 years. So what the state has done is create a list of preferred sites for solar development. And these are the sites that are eligible for these incentives. You can see the sites that we think are good, existing structures, so you're not doing ground-mounted arrays, landfills, brownfields, Superfund sites, previously developed land, anywhere that's not sort of pristine, undeveloped open space. This is where I want to come in, talk about Vermont's sort of inclusion of municipal preference. So Vermont passed Act 174, which requires municipal energy planning. Towns and regions have to go through a process of energy planning to identify sort of site types at the municipal level. So look at your town and tell me what areas of your town might fall into those different categories, and also what areas of your town you think would be great places to site solar, and what areas of your town would be bad places, conflict-inducing places to site solar. Once they go through this process, the sites that they've identified as good sites get the same rate adders as the sites that the state has identified. And let's pretend a site is not on anybody's list. You can actually go to the local planning board and the regional planning commission, get a letter from them. If they both agree, then you can get that individual site added to the list and get the incentive. So once you do this, when the project goes to get its certificate of public good from the Public Utility Commission, then the commission is required to give substantial deference to the town energy plan and the ordinances, the locations that they have put in the town energy plan. I think I'm running out of time too. So how can I feel like we've been talking a lot about preemption as a bad thing. And I'm not saying that this is a perfect process, but I think that at times, at least, this process and these sort of state level siting boards are undermining local authority for the better, dare I say. It takes a lot of pressure off of local boards, and energy is something that the state often has expertise in at the state level versus at the local level. Public utility commissions are often the ones working with utilities to do long-range energy planning, to understand where the distribution grid is and where the pressure points on the distribution grid is, where we should be adding more distributed energy resources, and where we already have too many generating resources getting contributed to the grid. Regardless of whether you're in a state or local process, I think it is municipalities who need to be making those parcel-specific determinations, where this piece of land over here is not good for development, while this piece of land over here is. So if the state is preempting local authority over things like solar siting, I think maintaining an avenue for that municipal preference, municipal opinion is incredibly important. So just broadly speaking about sort of state policies that affect solar siting and can kind of direct that process, establishing, a state can work to establish categories of project. What do we think is a small scale solar project? What do we think in our state is a large scale? So what is community solar? Creating those definitions that either the state can use or a municipality can use if you are in a state that has a municipal siting process can be really helpful. At the same time, you want to create those definitions of different land types. What is agricultural land? What is marginal farmland? What is previously developed land, if that's something we're incentivizing? I think that states or municipalities need to be doing sort of fast tracks for these small projects, roof-mounted projects, projects that are basically good public policy. And I didn't get into current use taxation at all, but I want to touch on it just momentarily. Most states have a beneficial taxation program for agricultural land, where instead of getting taxed at the market value of your land, you're getting taxed at the agricultural value of the land. And so if you're putting solar on projects that are enrolled in current use, you may risk getting penalized, getting tax penalties, rollback taxes on that land, and essentially getting kicked out of the current use program. So states have started making rules about this. When can you add solar to land enrolled in the current use program? And this is another thing that I think is sort of useful for the state to address at the state level and just make a rule about it. In Vermont, you can use up to, you can meet the energy needs of the farm, so 100% of the farm's electric needs, and then an additional 100% to sell without violating current use for the most part. In Massachusetts, you have to be doing a dual use or agrivoltaic project, meaning that the agricultural use has to continue. Things like pollinator habitat, the first photo was sheep grazing in and around the panels. The University of Massachusetts Amherst is doing a lot of work on what crops can grow in and around panels so that you can literally get 2 income streams off of the exact same parcel of land at the same time. So making rules for current use and making rules that sort of incentivize those agrivoltaic systems when solar is centered on farmland is important. And I think I have to stop now, even though I can talk about this for a long time.
Thank you. Maybe get back to Sarah after you've heard Heidi and Genevieve's talk. Any thoughts on how that relates to your concept of environmental federalism?
Yeah, I mean, you know, it was very interesting to hear these very specific examples of really environmental federalism in play. And I mean, I totally agree, right? There are instances where if a state has a robust regulatory program, well, then maybe the state should have, you know, then the state is kind of doing what it needs to do there. And we can talk about ways local governments can get involved. But I find that much less kind of problematic in terms of thinking about, you know, a robust, functional environmental federalism system. And so I think that, you know, going to kind of what Heidi was looking at in terms of ways that we need to think about how local governments can and are actually able to participate, that's what I find very kind of interesting and potentially problematic, is where there's failures of local participation. I think that's worth kind of examining. And then if local governments don't need a role, then maybe that's the answer in a lot of places.
Questions from the audience? Heidi, I got a question for you on the comparison between Ohio and New York with respect to denying or granting the 401 certificate.
Yeah.
And what is the relationship of like the state policy or the control of the governor over
Huge.
DNR in Ohio versus New York?
Huge, 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 huge. And that goes all the way back to, if you look at, you know, I'm going to put your question just a little bit aside and say that both Ohio and New York had lots and lots of local jurisdictions wanting to ban fracking, for example, and that the question was, can they, right? This earlier one looked at kind of the differences between those 2 states, and Ohio is just very different in terms of the legal context there. For example, we have home rule, but it was interpreted that kind of decision is not part of home rule, and it went all the way up to the state Supreme Court, and the state Supreme Court said, nope, sole and exclusive authority with respect to oil and gas related decisions goes to the Ohio DNR, no local decision making. The decision in New York was different. Their constitution is different. Their Supreme Court makeup is different. And, you know, that just kind of goes back to the importance of borders, right? And, you know, the same thing is true with respect to the granting or denying of the water quality certification permit. That New York's Department of Environmental Conservation is just very different in nature from Ohio EPA and is much more likely to be influenced on the side of the environment than is the Ohio EPA. You know, so it does come back down to the kind of the politics of the state.
Question in the back there.
Yeah, I hear ban fracking, ban unitization, ban pipelines, and of course where I live in Eastern Panhandle, West Virginia, where we don't have any of those problems at all. How do we encourage, and should we encourage, the development of solar? I mean, should our city become energy neutral or carbon neutral? Should we encourage our citizens to do that? And if we should encourage them to do that, what are the strategies we should use to encourage citizens of our town? What home rule things can we do that would make that better?
Well, I definitely think that you should be encouraging it. I'm from West Virginia. I'm also from the Eastern Panhandle. I'm from Shepherdstown. And I think so much about West Virginia's identity as an energy state. We have mountaintops that are relatively flat on top right now, right? With roads and infrastructure leading up to them and around them. We could be incentivizing solar, wind, other forms of energy generation. You could be exporting that energy out of this state if incentivized properly. I think having a net metering program, a robust net metering program, is a really simple first step. At the local level, I think permissive zoning for solar is important. Have your town go through that process of energy planning. What sites do we think are good? What sites do we want to make solar an accessory use, an as of right use in the zoning code? Those are some of the very first steps. And I think that, there's a lot more that can happen at the state level, but those actions can certainly happen at the local level.
Can I say one more thing? Sorry, I just want to emphasize that I think that the perspective I look at this stuff from is that not every municipality looks at these decisions the same way, right? Some of these jurisdictions, local jurisdictions, they want to ban fracking and they want to ban natural, oil and gas production, and others want it. They want it to come to their communities because it has some economic value. So it's not that I think preemption is a bad thing. I think there is a place for preemption. Where it makes sense to have a statewide system. It's just that I would like to see a system that is more open to local involvement in the decisions that are made, and that appears at least to be listening to the will of the local jurisdiction one way or the other, instead of preempting all involvement.
Yeah, just one last thing. I would just say a lot of times, all you can do at the local level sometimes is remove barriers, right? Especially in the context of energy development. There's going to be a whole state framework that's in place, but I do think evaluating, right, your building codes, your zoning ordinances, and making sure there's not kind of elements of those that are going to prevent people from even going down that road is a good first step. And I would just say, as a practical suggestion, for your community or others, there's this kind of national sustainable development code that's being kind of worked on, where it has a website, Sustainable City Code, and if you go on there, there's a ton of different examples, just really kind of model ordinances that local governments, it's focused on smaller communities, not the giant metropolises, but like smaller communities, and the actual actions they can take on things like energy development, other sustainable development measures. And so that can just be a kind of practical, helpful resource to generate ideas for what even to look for in kind of terms of, things that might exist in your building code that would be worth taking a look at.
Okay, with that, we're out of time. Let's thank our panel.